Appeals is now in session. Please.
Good morning and welcome to the Utah Court of Appeals. We have three matters on for oral argument this morning. The first is in the matter of KM. If counsel would state their appearances, please.
Caleb Prue for the appellant's parents.
Your Honor, Nathan Garcia on behalf of the appellee, the maternal aunt, who's present with me.
Pete Hackey with the Office of the Guardian ad litem, Your Honor.
Alicia Giles with the Office of Guardian ad litem.
Very good. I see that we have 6 minutes and 30 seconds left, or on the clock. So is the remainder for rebuttal?
That is correct.
All right. Unless anybody has any questions, we'll just allow counsel to proceed.
May I address the court?
Yes.
I think the 6 minutes and 30 seconds, so we're splitting time with the appellates in this
Oh,
case.
okay.
And then the remaining time will be for rebuttal. But he'll take 6.5 minutes, we'll take 6.5 minutes, and then rebuttal.
Okay, that's different. So that's okay.
So 2 minutes for rebuttal.
Is that right?
Did you see my math skills?
They're mad, yeah.
I'm getting the nod. so-
Okay.
Yeah.
Okay.
All right,
Awesome.
but,
2 minutes for rebuttal.
But appellant's gonna go first then, correct?
Yes.
All right, go ahead.
Thank you, Your Honors. And I apologize for not clarifying that earlier. I don't do this every day. With my time, I just wanted to highlight a few things in our argument, things that we believe are probably the most important issues before the court. And the first is the existence of an independent and fundamental right held by KM here, the child, in favor of family life. We believe that unlike the parental presumption, KM holds the ability and the right to express and claim that presumption in favor of fit parents.
Do you have standing to make that argument?
Well, I think we do. It's not necessarily something that we,
You're claiming a constitutional right on a party other than the party you represent, right?
yes. I think the ability of someone who is friend of a child has the standing to, for example, file for a child protective order. And so I don't believe that there would be any standing issue as far as biological natural parents raising that issue and having standing to do so. And I would just simply point out that I believe the guardian ad litem has joined us in every respect in this issue. I think they've framed it in a slightly different way than we have. But I see our positions to be consistent with each other. I think it's certainly somewhat of a novel argument, I would concede. But regardless of whether the parents have standing, we do believe that KM, through his counsel, the guardian ad litem's office, I believe that he's exercised and tried to claim that right. I think the question is how would he raise the issue? How would he claim it? And we believe by maintaining a consistent desire to be restored to the custody of his parents for 6 years and stating that clearly to both the judge and the custodial evaluation, that came into evidence. And so regardless of our standing, I think the right has been claimed by the child in this question, in this circumstances. Does that suffice, or is there any further questions about that?
I don't have any further questions.
Okay, thank you, Your Honor. The point, however, is that this independent right to be raised by his natural parents, we believe that that is independent of the parents. So even if the parents cannot, and we cannot claim the Hutchison-style parental presumption as outlined in our case law, we think the child's right is independent of that. And
I'm
so-
sorry, can I interrupt you? I didn't understand your brief to say that. You say you're not claiming that the court should have applied Hutchinson-like analysis?
Well, we acknowledged, and we haven't claimed it in a technical sense, because the case law indicates that even with the finding of dependency and a loss of custody, that the parents in that circumstance can't claim it on their behalf, as it's been styled in Hutchison and the later cases. We did make an argument simply that the factors that Hutchison outlines, substantively, those factors, those being whether or not there's a strong parent-child bond, a strong mutual bond, whether the parents have demonstrated a willingness to sacrifice their interest and welfare for that of the child, and whether they possess a sympathy and understanding of fit parents. Substantively, we've argued that those are indispensable and required factors to be looked at in any best interest analysis in a case like this.
And I want to ask, so I understand that the petition for termination of parental rights had been withdrawn, as I understand it here. So the question before the juvenile court was whether, one, to continue the temporary guardianship, and two, to convert it into a permanent guardianship. Do I have that correct as to what was before the juvenile court at that evidentiary hearing?
So it had been anticipated that at the conclusion of the evidentiary hearing that the court would be ruling on the matter of our request to dissolve the temporary guardianship and restore custody or make other appropriate orders.
So that was the only request or pleading pending before the juvenile court at the time of the evidentiary hearing, correct? I mean, there wasn't a petition pending from the temporary guardian to terminate the rights. So the only decision the juvenile court could have made was on your client's petition to terminate the temporary guardianship.
Wasn't have to.
Wasn't there a pending cross petition to make the guardianship permanent? So there were actually three questions that just juvenile court was addressing. One was whether to have it just perpetuate in its temporary status. Two, whether to make it permanent, or three, whether to dissolve it altogether. The one thing that had been rescinded was the petition for termination of parental rights. Is that not the landscape?
I think that's correct. Mr. Garcia might be able to address what exactly they had pled, but I think that's correct, Your Honor.
And so as I understand your argument then with the Hutchison factors is that not that they technically applied and that the case itself should have been followed, but that the factors themselves were relevant to the decision of the juvenile court in making the determinations with respect to the guardianship and whether it should continue, and if so, in what form.
Correct. We raised this in the post-judgment motion, and I believe also prior to the evidentiary hearing in the trial court, just simply never made those findings. But that's the gravamen of our argument. It was essential and required, given all the other facts and evidence and given what we were requesting, it was essential and required for the trial court to address those, the strong mutual bond, whether the parents had demonstrated that willingness to sacrifice. And we just see that as a fatal flaw. If those factors aren't addressed and there weren't findings, then it was an abuse of discretion, because that's a type of abuse of discretion where if a court does not address or weigh certain relevant and necessary factors. So that is correct, Your Honor. And it looks like I've run out of time.
I have just one question.
There's a question pending.
And the reason that the Hutchinson factors are relevant to this situation is because we're in a different sort of procedural posture than the state is not, at this point, the state is not involved necessarily in the custody, in petitioning for custody of a dependent or abused or neglected child, right?
Correct. Basically, the parental presumption and those factors, as I've always understood it, applies when the parent is dealing with a custody fight with a non-parent. And so it does include the state, because there's case law that says, as soon as the state files a, child welfare petition, then the presumption goes away. So I think various other parties are treated differently under the case law, but I think what you've stated is correct. The bottom line is because of the previous finding And because my clients did not have custody at the commencement of at least the current or most recent pleadings and petitions, we couldn't claim it under the case law. But essentially, and this isn't necessarily the case to deal with this, but I think there's dispute as to when the parents can regain that presumption and claim it again, whether that requires a finding by the court or just whether that happens de facto. So I think that's where kind of we are essentially, as far as, I think the court needs to answer whether or not it applies in certain respects, but hopefully that's helpful.
All right, thank you very much. We'll turn to the guardian ad litem.
May it please the court, Heath Hackey with the Guardian Ad Litem's office. Good morning, Your Honors. I want to start just by pointing out some pretty significant differences between the argument, because the court had raised the issue of standing and whether or not we could address the concern regarding the child's separate and independent presumption to be raised by parents. I want to be clear with the court that it's our position in this case that neither Hutchinson, because it's been codified in the juvenile code and no longer applies within the context of the juvenile code, that doesn't apply because it's been incorporated into our codification. And I think there was some statement that because the state was involved, the juvenile code is not limited to when, or Hutchinson is not limited to whether the state's involved. It deals with the parents versus another party, and that could be an aunt or the state. But our position outright is that Hutchinson doesn't apply because it's been incorporated in several provisions under the juvenile code. So I want to create that distinction. We also feel that the parental presumption doesn't apply in this case, and I want to make that distinction very clear. And the parental presumption, and counsel makes the argument that there's an extension to a separate and independent presumption regarding a child. Insofar as that is the case, and stepping back, that attaches to the parental presumption. And like in this case, the parental presumption was overcome at the time of adjudication, which the cases represent. So insofar as the child in this case did have a presumption to be raised by a parent, that's a fit parent. A child doesn't have a separate and independent right to be raised by a child that's being deemed to be unfit, and that's exactly what happened in this case. So we don't feel like at this point the parental presumption applies because we're past the adjudication phase of this case.
But so you see the child, what's being argued as they're independent. While it might be independent, it's the flip side of the same coin.
Correct.
And so the adjudication, our case law indicates quite clearly that the parental presumption does not apply if there's been this adjudication. So you're saying that this concomitant child presumption, should it exist, rests on the same grounds. Is that
Correct.
right? Okay.
That would be correct. And then Judge Oliver, you'd indicated what was before the court at the time. And I want to create some clarity with respect to that because there were several things that were filed before the court. There was a motion to terminate the temporary guardianship, which was before the court at the time. There was a subsequent petition that had been modified that was before the court at the time. And then the most important thing that I want to point out to the court that we point out in our brief is the original petition that was filed was also before the court in a dispositional phase at the time that this order was entered. And so those were the things that were ultimately before the court that the court ruled on. But I want to get into my argument because our argument ultimately reached the same outcome, that the order ought to be reversed, that the order regarding permanent custody and guardianship ought to be set aside, and it ought to be remanded with an order to restore custody to the parents. And in this case, our argument is different. Because in the dispositional phase of the case, we look to and we point out in our brief that the court misapplied as a matter of law 80-3-409. That what was before the court was a question of whether the child could be safely returned. So
If we agree with that,
I'm sorry?
if we agree with you on that the court should have applied that and that it's either the court didn't or it's unclear whether the court did, under either scenario, isn't our determination then to remand to the juvenile court to apply the right standard? It sounds like what you want us to do is then say, dear juvenile court, you applied the wrong standard, and had you applied the right standard, there could have only been one result.
Well, that could be one option, but our position is that the findings that the court did make and the evidence that was before the court was sufficient to find that there was, in fact, no safety concern. If you look specifically, and what I would cite to in terms of the court's findings is the court had outlined several factors, and it was a binary test saying the parents didn't meet X, Y, and Z, and in this case, that was the mother's mental health concerns, the housing issue, and then some drug testing that the mother had missed a drug test in this case. But the court found no findings regarding the father. In fact, the evidence that was before the court at the time was that the father had completed virtually anything. If you look at the court's findings when it awarded permanent custody and guardianship, it made no findings with respect to the father. And I know that there is some case law that states, well, if you have one parent in a home, that could be a concern, except for the court didn't find that the father wasn't protective in this case. In fact, the juvenile court in this case found that the father was protective. Juvenile court went so far as to say.
Supervising the visitation
Correct.
with mother.
Correct. That was the court's finding. The court found, in fact, in this case, at least as the father was safe, and that the mother was safe in the home as well, because the court actually ordered that the father could supervise mom's visits. So how could the court also then find that it was unsafe? Because the court's, in and of its own order, found that it was safe enough for it to be in the home. The court made no findings regarding the father's protective capacity.
So can I ask the practical import of that? It sounds like there's a distinction then that you're making between the findings below as to mother and father. So to help flesh out the answer to Judge Mortensen's question, would a remand be different then with respect to the two parents? So a remand that custody be returned to father and then further findings be made for mother? Or I understand that you're making a distinction. I'm just trying to figure out what the practical import
Well,
of that is.
and I think that from a starting point is that you reverse the order of permanent custody and guardianship, because that very clearly, if you're restoring custody of one parent, because that's consistent with the court's orders, that would be a consistent remand order, even if the court were to remand. But I don't even think that there's a remand necessary for the mother, because inherent in the mother's findings was that dad was protective. They're together. And so, and also, as to the findings regarding the mother, the court did not make a nexus as to what those safety concerns were. So the court looked at it through the lens of a binary test. Did you complete the services? The court cited the mother's mental health, except for the court didn't articulate how mother's mental health had related to a safety concern. In fact, the custody evaluator in this case had testified that she didn't think that that in and of itself was a safety concern. As to the drug testing, you had a similar, in fact, I think the custody evaluator had testified, and we cited in our briefs, that if this were a parental fitness evaluation, the parents were sufficiently fit to raise the child. That was the issue before the court, is can this child safely be returned with or without services, given the particular circumstances of a 13-year-old child, who in this case had testified several times to the court that not only that he felt safe going back home, that he desired to go back home. So there was that issue. Mother's mental health, the court didn't articulate how that created a safety concern. As to the testing, mom did miss a test, but as we point out in our brief, mom had also undergone an opiate program that she was engaged in, and the missed test in and of itself, or the refusal to do a hair test, did not in and of itself pose the issue of a safety concern. And then you have the third finding as to mom and dad regarding housing. But that in and of itself is not a safety concern, because otherwise we'd be in a situation that every parent over at the road home shouldn't have the parental presumption. That simply is not what the Utah law contemplates. So I understand. And not only that, the court had actually made a finding that housing in this case was okay, but it didn't think down the road it'd be maintained. That's not a basis that 409 contemplates to keep the child from returning home. It was purely a safety issue, and the court didn't address this through the lens of a safety concern. Also under 409, I would point out it requires the court to look at the issue of sibling contact under 80-3-409 subpart 9. It indicates that that the court also has to do an analysis regarding the sibling contact and how that relates to the child going back home. And notwithstanding that there was evidence throughout statements from the child that he wanted to return home to be with his siblings, that was never addressed in the court's final orders. So you have a total and complete disregard of the Section 409 analysis by the juvenile court, and the findings that the court did make as to mom in terms of safety didn't really relate to safety. It was a binary test. Our position with the court, therefore, is that the parents had received a present fitness sufficient to regain the parental presumption at the time of the permanency hearing, sufficient in light of the particular circumstances that the child in this case could be returned with or without services, and we include that. So in terms of the practical effect of this order that the court continues to have, if the court maintains jurisdiction after restoring custody, to actually implement additional services to make sure that the child is safe in this case. So if the court had concerns regarding housing, the court has the ability to join another party under Rule 18, including DCFS, to provide protective supervision services. If the court had continued concerns regarding a mom's mental health, the court has the ability to join a party or require a mom to continue to engage in those services.
Can I ask
Yes,
what might be a sort of a silly question, but does 409 even apply here? Doesn't 409 contemplate the circumstance where the child is removed from the home and we're figuring out, because the state is involved, because DCFS has custody, the court has ordered the state to have custody of a child. They're acting as the parent in that circumstance. Whether to return, 409 contemplates that situation, whether the child can be safely returned to the parent at the permanency hearing.
409 applies. And in this case, because 409 references 406 and reunification services, and there are provisions of under 406 that state that if a child's removed or placed in DCFS custody, but there's provisions also under 406 that aren't limited in that respect. What the court effectively did in this case was provide reunification services, which implicates 409. Because if we didn't have section 409, and by 409 I mean 80-3-409, 80-3-406.
Right.
If we didn't have that, there would be no guidance for the juvenile court when to terminate services or when to, or under what standard the child would be returned. So the state being involved would have, the statute doesn't read that narrowly, in my view.
Okay.
I think it applies, yes, typically in the case of a child's removed, but not necessarily in the case where a child is in state custody. The other thing I would point out to the court, that the juvenile court is a court of a limited jurisdiction, where the purpose of the juvenile court is not to be involved perpetually in custody type scenarios, like in this case, in excess of 6 years. Juvenile court is involved when there's safety issues regarding children, and the legislature has made clear that when those safety issues are resolved one way or another, the juvenile court ought to be out. That's why it's important that 409 apply, because otherwise there would be no standard. Section 80-3-409 not only gives the court a standard by which to return the child home, whether the child's in state custody or not, but it also gives the court a timeline to do that. So that's the importance of 409 applying, 80-3-409 applying. It not only relates to, no, it can't be read that limited, and also that the court is a court of limited jurisdiction and can't be involved in a way that we're just perpetually involved in a custody case. We also point out in our briefs that the court improperly engaged in a release restrictive analysis, that this was not a case for termination of parental rights. The court went into some detail. It impacted its findings in this case that it was looking at permanent custody and guardianship instead of termination. There was never termination before the court. And then we also point out in our brief that the child's desires, and I know counsel made some argument about in the response brief about the child not being 14 years old. The child very clearly in this case had not only not articulated a safety concern, but had consistently said that they wanted to return home. And there's several provisions in our statute that say that the child's not only need to be at the hearings is important, but also that their voice be heard. And we feel like the court, it's our argument today that the court ignored that evidence regarding the child's position or glossed over it at best. So, does the court have any further questions?
Nope, thank you.
Thank you.
Mr. Garcia.
If it may please the court, I'm Nathan Garcia on behalf of the appellee aunt, maternal aunt, who's present in the courtroom. We take the position, and our brief argues that the trial court in this matter took the right action and the appropriate action. We have a situation here where in 2017, the parents were dealing with some serious issues. And in lieu of state action, i.e. DCFS involvement, the aunt, my client, stepped forward and offered to take guardianship and custody of her nephew, and he's been living with her ever since, and has provided more than adequate care, great care for this child. And the court, in making its determination, acknowledged some of the things that aunt has done to make sure that this child was well-fed, well cared for, well-educated, and some of the things that the parents, over the year sort of trial that they had to try to regain custody, that they failed to do. And the court, I think that it's important in this analysis that the court recognize that the aunt has done a tremendous amount of service to this child, and that Judge Bartholomew, in reviewing this matter, recognized that was an important relationship that had been established over the intervening years, and that she had done a fantastic job of caring for this child.
Can
I
I
think-
ask you a follow-up to Judge Christiansen Forrester's question? It appears to me from your brief that as to the applicability of 409, you affirmatively argued that it was applicable. Did I misread your brief?
I argue that that it is I guess, a roadmap that the court could go through, but I don't think
Page
that's-
9 and 10 of your brief says, while reunification services were not offered in this case, there were stipulated conditions, and you said that this was akin to reunification services, and then the next paragraph, you specifically quote 80-3-409, and it appears that you're arguing that should apply.
I'm arguing that the court should look at 409 as a roadmap or something, because I don't think that the statutes adequately deal with this particular type of situation, because this isn't a DCFS involvement case, because this is a private guardianship, and specifically in this situation, because it was a private agreement between the parties, and I do point out that the genesis of this really comes down to a stipulated agreement that became an order of the court, and that the court had to review, was there compliance by the parties to this order, and it had that compliance been achieved, then I don't think that we would be looking at 409. The court would have just said that we've achieved what we were set out to do under the stipulated order, and the parents have now can regain custody and care of the child. But
So-
because they failed to do so,
So it sounds like then your view is not that there's the statute that should be followed, but rather the only thing that matters in the case is the order itself that was stipulated to. And it was either you comply with the conditions to end the guardianship or you don't. Am I mishearing you there?
I think that is the starting analysis for the court is, was there compliance or not? But because the issues were raised by the appellants and also the guardian ad litem's office about some of these attendant issues that are in the statute, that the court did use some of those factors in its analysis to especially with the post-trial motion to further clarify why it was making the determination that it made. But
So at the end of the day, what is the juvenile court deciding? Is the juvenile court deciding yes or no, you complied with this order and therefore custody is X? Or is it considering, given the totality of circumstances in this case, the order being part of that, the present fitness of the parents being another part of that, safety being a part of that, whether the guardianship should continue? I guess I'm struggling to figure out where you land in that, because it seems to be two different ways that the juvenile court could have looked at it.
I think that I am straddling both sides of the fence, because I think that the court has to do that. I think that the court has to initially determine whether or not there was compliance. But if there
But that's
wasn't
not the
compliance,
end, right?
it's not
So-
the end, because the court still has an independent duty to make sure that the agreement was in the child's best interest, or the underlying order that the parties agreed to, that order was still in the child's best interest. And the court then looked to the different statutory schemes to determine what would be in the child's best interest, and given the totality of the circumstances, found that the best interest was served by keeping or giving a permanent custody or guardianship to my client. And so that's why I sort of straddle both sides of the fences, because I think that the analysis ends if the court finds that they strictly complied. But if they didn't strictly comply with the agreement, then the court it still has an independent obligation. And so 409 is one area of the case law where they can look to and find some of the factors that the court can consider in making a best interest determination. But this wasn't a traditional permanency hearing, as I think Your Honor points out, that that would be more akin to a DCFS investigation, and where the state does have custody and reunification services have been offered. But as I argue in my brief, the situation was similar, and so I think that the court can use the circumstances of the case and see that the court still made the right analysis as it went through the factors in making the determination and finding that the child's best interest was served by keeping permanent custody and guardianship with the aunt, given the fact that the parents had failed to strictly comply with the order, which I don't think that either the appellant or the guardian ad litem's office perfectly addresses. I think that there's some argument that dad did comply and mom didn't comply, but that's not entirely true either, because one of
That's
the
what I was gonna ask you. I wanted to, we're sort of treating the parents as a collective, right?
Correct.
But there were, what findings did the court make that shows, I guess, that father wasn't?
In complete compliance. I
Yeah.
think the concerns that the trial court raises, and I cite to, I believe it's CZ, where there wasn't stability in the situation that they had acquired. So the deadline for them to get the housing and to get the job, and dad was the one who was ultimately, mom didn't work, so it was dad who got the job. But the court took concern with whether or not that was actually stable, meaning that it happened a mere couple of weeks before the deadline was to elapse. And so by not getting into stable housing and to have a stable job situation, the court didn't feel that that was stable enough to meet the requirement under the agreement that they have stable housing. So in a technical standpoint, sure, they did have housing, but given that it was a recent acquisition and that the job was a recent job, the court, given the totality of the circumstances and the years in which these types of circumstances had arisen, so this wasn't the first time in which the court had set out a rubric or a set of actions that the parents should take, and then had fallen short of that. And so given that history, the court recognized that this wasn't, in its view, stable housing. And
And this maybe is just a comment, more than a question, but, and I don't know the specific circumstances of these parents and of this family, other than what's contained in the record and in the court's findings. But doesn't that seem to punish people who don't have means, to the extent that if they're relying on government assistance for housing, they're sort of at the whim of when it's available and not based on when they need it necessarily. I mean, do we just not consider anything like that? Did the court consider anything like that?
I think the court did consider that, and I think that the record reflects that the parents, the housing that they did secure was secured through, I believe, Section 8 vouchers. So I think that the court recognized that it did require some of that process, but I think that the court was also at the mercy of the fact that the parents agreed that this wasn't the court's, it did become the court's order, but based on the party stipulation, that would be a requirement that they would have to set out to show that they had that stability, so.
But didn't they actually accomplish that in time? It seemed to me they had the income and the housing arranged prior to the hearing and all of that, but the court's concern wasn't that it wasn't in place at the moment. But as I read the order on 1137 of the record, it's that it remains to be seen whether they can remain in the home, or that it's too recent, basically. The court was saying, yes, you did it, but I just don't know if you can maintain it going forward. It wasn't that more the concern than they failed to meet the requirement of the order?
Yes, no, I think that's exactly right. The concern of the court was because of the recency of gainful employment and of the housing, that the court was concerned that meeting that technical requirement didn't actually meet it because the stability wasn't there. And I point to, like I said, I believe it's CZ, which was another case that had a sort of analogous situation where the court had upheld that was a valid concern of the juvenile court, and that's the concern that Judge Bartholomew raised as at least in the circumstances how we got to here, dad's inability to fully comply with the stipulated order.
And so going back to, I think, the question that started this, this line of discussion, the only finding then that the juvenile court made with respect to father, and his present fitness or his ability to comply with those orders, is this lack of maybe confidence, I'll say, by the juvenile court going forward with respect to the income and housing stability. Is there anything else in the record in the findings by the juvenile court with respect to father falling short in any of the considerations?
I think that there was a couple of small, minor things that I don't think that the court had really punished dad for or cited to, but in the record itself, there was some issues with a minor arrest that had been made that was like a loitering or something like that, but that the court didn't find that was enough to sort of give a high concern about to the extent that we're talking about safety, a father's safety, that generally speaking, that he had done what he needed to do in relation to his drug use and to his criminal record. And so there was a more concern related to the mom, her mental health, and then also the missed drug test. And
So getting back to the 409 issue, is it your view that there are enough findings in the juvenile court's order that it essentially meets the requirements of 409? Because if you're saying that 409 should be the guidepost, and the guardian is saying that the juvenile court didn't make those findings, then where are you in terms of the findings with respect to 409?
I think that the court's findings were sufficient to, if the applicability of 409 was strictly to be applied to a guardianship type matter as opposed to a termination of parental rights matter, that the court made enough findings to find that it was in the child's best interest and that it didn't run afoul of the other factors. So I believe it's either subparagraph 9 or 10 says that the court ultimately has to look at the best interest, and as long as it doesn't run afoul of 4 through 8, then that would be sufficient to meet the requirements of 409. And I also think that I point to the harmless error, which is even if the court had not strictly gone through the analysis, that it would still be a harmless error because the conclusion would still be the same conclusion, because the court also pointed out concerns related to the parents during the period of time in which they were, trying to regain custody, that they were failing to get the child to his doctors and dentist appointments, that his grades had been suffering under the parents' tutelage, as they were the ones who were responsible for his academic performance during that school year. And so the court had made those additional concerns layered on top of the original stipulation that was there under the order that the parties had agreed to, of additional concerns that the court had about returning custody to the parents, because during that period of time they had failed to do those important things that the court also took concern with.
I don't see any other questions, so
All
thank
right.
you very much.
Thank you, Your Honors.
Thank you.
Back to the appellant.
Thank you. Let me just address a few things. As it relates to the question about whether 409 applies, I would also point the court to 405, which is titled Dispositions After Adjudication. So it's in the same chapter, Part 4, adjudication, disposition, and permanency. And under 80-3-405 subsection 2, it talks about, says, quote, "The juvenile court may vest custody of an abused, neglected, or dependent minor in the division or any other appropriate person with or without court-specified child welfare services in accordance with the requirements and procedures of this chapter," end quote. So even if 409 doesn't necessarily on its face address circumstances like this where DCFS is not vested custody of a child and we go through the normal child welfare reunification process, I think this section 405 does specifically address these circumstances, and so I think the chapter does apply. I will say too that we took it, and I think it's essentially undisputed that in 2022 with the agreement we were trying to approximate a reunification process, more or less. At least that was our intent. We adopted the custodial evaluators' recommendations with some modifications as a roadmap, as a child and family plan. And so I would just finally point the court to one of the parts of 80-3-409, which does apply. Under that, under 2C, it says, quote, "Prima facie evidence that return of the minor to a parent or guardian would create a substantial risk of detriment is established if," and then it talks about failing to participate or comply with the child and family plan. So, and I don't believe that the word strict compliance was ever used in the 2022 agreement or order. It's our view that it's the substantial compliance of the parents that establishes the fitness and is the bedrock, along with KM's desires, that indicates that it's in his best interest to be returned to the custody of his parents. And then one last correction, the minor misdemeanor that was post 2017 and 2018 was actually on the part of mother, and it was a tobacco in a park. I think it was incorrectly stated that it was father's. So unless there's any further questions, we would rest.
I don't see any further questions. We appreciate your arguments today and your previous briefing. We'll take the matter under advisement and issue a written opinion, hopefully with some dispatch. So, thank you.